guys, I thought I would do a quick explainer video for you just on doing case notes. I've seen a few of your case notes and there's a few common issues there, so I thought I would give you a few tips, a few pointers, might make the process a little easier for you. It's important that we get our heads around how to do a case note because you'll be using them all the way through your degree studies, in fact most of your professional life I would suspect. And so you need to know that you're doing them well. The other thing is that they're not normally set as assessment, so you don't have to get a particular lecturer's view on how to do a case note. I mean, obviously if it is part of an assessment in a unit, then you need to make sure that you comply with that lecturer's instructions on how to prepare a case note. But in terms of where we're at for contract A, there's no assessment based on submitting a case note. So what we're really trying to get you to do is get into the habit of summarising cases so that you do them regularly. Ideally, summarise the important cases each week, and then that way you've got a nice little collection of your summaries by the end of term. That comes in super handy when you are preparing for your exam, okay? No point spending SWOT vac, going all the way through the casebook again and thumbing through the many pages that you've read till your eyes bleed during term, if you can have a nice little concise set of your own case notes, okay? It'll make you feel much more comfortable, and you can take them into the exam. You can put your little post-it notes, law student's best friend, all through them, and you can get everything that you need at your fingertips. The other thing, the other really great thing about preparing case notes is that it tends to promote deep learning. So as you're actually preparing your case note, bingo, the information's actually going into your head. As you're sifting and sorting out the material and getting it onto paper and putting your summary into your own words, it's actually, this stuff is seeping into your brain by osmosis. So it's a useful process, not just in terms of your end of term swap back, but also for your longer term retention, okay, and for your understanding of principle. Now, if you go to the Moodle site, one of the first sources that I've got up there for you is reading cases. Okay, now there, I suspect this is where some of the students have got it from. They've looked at this head note and they thought, here's a case note. Actually, this is not a case note. This is a head note. It appears at the top of the official reporting series. So here you can see this reporting series is the Supreme Court of South Australia. You can see that up the top there of that head note. So that's the reporting series. But because it's a head note and not a case note, this head note has to capture all of the official information that you might need in order to follow up on the parties, the case, subsequent cases, and all of that kind of stuff that you might not necessarily need for your own purposes for a case note. So in terms of a case note, you probably wouldn't need to do things like put in the full date. Why is that? Because usually the year will be sufficient and the year is contained in your citation, okay? What other things might you not need to know or put into your case notes? You don't need to put catchwords, okay? Catchwords are purely used by head notes for the convenience of practitioners that are busy and short of time and want to know what is going to confront them when they read the full case, okay? If that case is about stuff they're just not interested in, then they're going to flick on to the next case, okay? Head notes are there for practitioners. Case notes are your own personal work for your use. You already know roughly what the case is going to be about because of your organisation of your notes. So I would hazard a guess, no real need to use catchwords. Then you've got your little summary of the case. You don't need to put into your case note the cases that have been cited in the case that you're summarising, unless it's important to a particular point, and I'll come back to that in just a minute. You also won't need this arrow down the bottom to know the names of the people, the barristers that have appeared for the appellant or here the respondent. Okay, don't need to know that stuff. Yes, barristers are very important, but you've got much more important things to be doing with your life than writing case notes that include barristers' names. So that's what I would say to you. A case note is intended to be something quite different to a head note. Now, if you go back to the Moodle site, you can see here, I did have an infographic up from Sydney Uni, but that's now been locked down by Sydney Uni, and so they've got it only for their students, but the Deakin Uni one is still there. If you have a little look at that one, you've got, it looks like this is on the Monash Uni, sorry, it's Monash, not Deakin. You've got it on the University Library website there. Bear in mind, this may not have been prepared by lawyers. What they are suggesting that goes in, case citation, parties, type of court, date, judge, major arguments, ratio, decision. Now, I would say you could distill that down further, because the case citation includes the names of the parties and also the citation to the reporting series as well, which will also include the year. So if you do one proper case citation, that will give you all of that information right there in the one-stop shop. Okay, so that's what I would say about that. It is important to include reference to which judges sat on the bench. And I wouldn't do a separate section for the major arguments. I would just cover that off in your summary of the ratio if that's what you wish to do. Yes, you do need to put the decision down the bottom. Okay, so for the task for week 1 of the skills module is to have a little look at Carlisle, the Carlisle case. And there are a number of different sources, sites that I have suggested. Some of those sites will work, some won't. You will hit roadblocks, but one will. And I will jump across to that one in a moment. I want you to, even though I'm showing you here, I still want you to have a look at the other websites, predominantly just to show yourselves that you can actually navigate through those websites, because these are the websites you'll be using forevermore. Now, if we have a look at the case on one of such websites, as you can see there, it's Bailey, you'll find the case in full. Now, I've also, here's something I prepared earlier, and I have started my case note to the side there. Now, if you have your document up at the same time you have the case, it kind of makes things easier, because what you can do is you can copy the case name, and you can go across to your document and you can copy it into your case note. And you can go up here and the citation will be right there for you. And you can copy that and then go across to your case note and dump that in there. So you don't have to be constantly typing things yourself. You need to know that EWCA stands for England and Wales Court of Appeal. And then you head on into looking for who are the judges. So you can see here, Lindy's the first one, Bowen, and then down the bottom, good old Smith. Okay, so you pop that into your case note. Then you just want to skim read the case and pick out the facts that you think are most important to start with. Now, you might reshape that when you come back to it, but that's what you would put in here. Okay. Like I said, these case notes can often be a bit of a work in progress as you're going through. Now, the main thing that you want to have in your case note is a really good record to your mind that will make sense to you later about what was said in that case what the ratio was, what the orbital was, what the ultimate decision was. Okay, main things to have in your case note. Now, this is just the way I do it. But take one, put a bookmark there, and we'll do a little bit of a side note. In GRAW, there is a reason why I've asked you to read Chapter 1 of GRAW, and Chapter 1 of GRAW, for those that haven't done any law before, is useful because it explains the process of how a court arrives at a ratio, or what we would say is the ratio, and how cases are distinguished. Okay, so have a particular look at 1.200, so the doctrine of precedent, 1.200 through to the end of 1.260. Okay, super useful parts there of GRAW. And the things that you need to note is that there is a difference between ratio and obiter, and the ratio is the maybe several in a case. And a ratio of a case is a conclusion on a point of law for a particular reason. And if you have a multi-judge bench, then you need to work out for yourself what the ratio is. The ratio will be, as I said, the decision that was arrived at for a particular reason. Now, it might be the case that a couple of the judges agree on the decision, but they arrive at that decision by means of different reasoning. Now, that is not a ratio, okay? In such a case, if you had two judges deciding one way and one deciding another way, then only the two judges that agreed on the reasoning to get to that conclusion will be the ratio. You'll never find the ratio in the dissenting judgment, okay? If, in fact, out of those three judges on this fictitious bench, you had all three judges agreeing on the decision, but each using different reasoning, or two out of the three agreeing but each using different reasoning, then there is no actual ratio, and we say that the case was decided on its facts. Okay, so this is why I've gone through and done my case note the way that I've done it, because it helps you to work out what the ratio is. Now, I understand that as you're going through, it is a bit difficult for you guys because you're really finding your way in terms of what to look for in the law, because you haven't done a whole lot or any principle yet. But it's useful to bear these things in mind as you wade through the first half of Contract A. The main thing that we are looking for, as I've said to you in the introductory video, and I've also said to you in the week 1 videos, is formation of a contract. So intention to create legal relations, capacity, offer, acceptance, consideration. These are the main things we're looking at for the front half of this unit. So you can probably bank on the fact that the cases I'm getting you to look at will contain a discussion of those kinds of issues. And in fact, that is exactly what happens in Carlile. It traverses a number of different issues. And so what I tend to do, and I hope you find this useful also, is that I go through each judge and I list out what I think the main things were that they touched on in their judgment. And then I do that for each judge, so Lindley, Bowen, and Smith. And then I can flip through what I've noted down as important that each judge remarked on, and I can see if any of those remarks tie up, because where they've used the same reasoning on the same issue, then I can say with some confidence that as long as there are 2 out of the 3, there's going to be a ratio of the case on that point. Okay, so it might seem a bit long-winded, but you guys have kind of got your trainer wheels on, so I've done it in a somewhat longer fashion than I perhaps ordinarily would. Of course, when you're doing all of this for yourself, you can use your own shorthand if you wish to do so. So, for example, when it comes to intention to create legal relations, I will just put something like intention to create legal relations like that, shorthand for myself, an acronym. And that saves you typing the whole thing out when you know what you mean. All right, so you go to the case. Generally what you'll do is you'll have a quick squiz through the case itself. Very quick skim. And what that skim will do is it will help you put in there the facts that you think are, the most salient to note down. Obviously, in this case, Khalil has seen the ad. She's bought the smoke ball, she's used the smoke ball, it hasn't worked, she's still caught the flu, and so she wants her £100 that was offered in the ad. So when we go through Lindley then, he starts by saying, I'm going to refer to 2 points raised in the court below simply for the purpose of dismissing them. Now, where a judge flags something like that, you're like, great. I don't really have to read terribly carefully what follows there because it's not going to form part of the ratio. If he's just said, well, you know what, the barristers tried this one on, it didn't fly. I didn't like the argument, I don't think it's relevant, and so I'm dismissing it. So then what is left? You see, I've skimmed straight from there, dismissing, and then I've gone straight to, okay, don't really need to know what is really in the rest of that paragraph. And you can see there it ends with not worth serious attention. So, hey, there's a paragraph you don't need to worry about. I will pick up on that later. Then what's left? So then we start getting to the meat of things. Okay. First, he's just making an observation here. So again, that's going to be obiter only, because remember, obiter are just observations. They don't go directly to the ratio. If you're interested in the obiter, you'd read on. If you're not interested in the obiter, then you're not. Here they're starting to talk about inferences of fact. You don't really need to know about evidential rules or anything like that at this point, so I wouldn't really worry too much about that. Then you can see, beginning of the next paragraph, immediately he says, we must first consider. So here he's really getting down to tin tacks. Intended to be a promise. Intended, there's a flag, isn't it? Intention to create legal relations. To be a promise at all, or whether it was mere puff. Okay? So what do you put into your case note? Was it a promise or puff? Okay? What did they say about that? You skim down and you put the answer into your case note. Then it is contended. So can you see what I'm doing? I'm looking for words in the paragraphs that will flag for me what I need to quickly hone in on. Okay? The next point, is it binding? Is it not binding? All right? So then I've put that as my next issue in my case note. Carbolic said no because it wasn't directed to anybody in particular. What they argued was you can't have a contract unless you had two specific parties. You can't have a contract with all of the world. And there was something fairly special that Lindley said about that issue, that particular argument. So I've noted that in my case note. Then it was said, supposing the performance of conditions is an acceptance of the offer, acceptance should have been notified. Now we will go through offer and acceptance later on in term, but what you need to know for now is that obviously we know that they're hallmarks of the formation of a contract, so that should probably go into your case note. So the thing that they're arguing about is whether Mrs. Carlyle actually told Carbolic that she had accepted their offer, because normally that's what has to happen before a contract is formed. So they argue a little bit about that point, and that needs to go into your case note as a separate issue. Then you find, we therefore have all the elements necessary subject to two observations. Okay, Then they have the next objection, vagueness. That goes into your case note. What did they say about that? Here, too vague. And then, and there's just one other thing that says here about construction. That could probably be a subpara of that. And then they go down here. You see he's got lovely flags at the beginning of his paragraphs, hasn't he? I come now to the last point requiring attention, consideration, okay? So then obviously that's something else that was considered here that you need to pick up on. So what was said about the consideration in that case, and did it fly? Did it die? Okay. Then they talk about a case called Gerhard and Bates, and they say something in particular about that. Now, I want you to flag that because this will probably, if this is your first unit, you may not have encountered the phenomenon of a judge distinguishing a case before. And Graw talks about distinguishing in paragraph 1.250. Hey, right there. The way to do a fancy footstep around an inconvenient case is to distinguish it. And there are a number of different ways that Graw tells you that you can distinguish a case. And here they distinguish Gerhard and Bates, which seems to have also been a case of not reward, but an offer. They distinguish it on the basis of what we call privity, and we'll be discussing privity at the very back end of Contract A. So you can see that they've distinguished that case that had a rather inconvenient ratio so that they didn't have to follow it here. Otherwise, that case would have stood in their way and they may have had to come to a different decision. Okay, so you need to just work out what they've said about the Gerhard case. Then you go down to the next judge, Bowen. Okay, and here, first observation, it's not a contract, it's just an offer made to the public. Well, he kind of dismisses that out of hand. The defendants contend next, it's an offer of the terms that are too vague. Okay, I think we've heard that before. Lindley said something about that. Okay, main point made by the defendants, vagueness of the contract. Okay, so you're away with your next judge now. And then you go down how to construe it. Was it too vague to be construed? Actually, that should be a sub-point again like the other one. And so should this one. All right, the next thing. Was it intended? Again, another red flag, intention to create legal relations. And then they talk about that. What does Bowen say about that? Then, was the contract made with all the world? Was the contract made with all the world? Okay. So you carry on like that and you list out the main points that each judge had to discuss and find for or against. Okay. So then you do the same with Smith and you work out what the ratio is. So you flip back to your notes on Lindley. He says, wasn't a policy, wasn't a bet. Just going to dismiss those two arguments right out of hand. They weren't even in the ballpark. And in fact, if you go down to Smith, you'll see so did Smith. So, you don't have to worry about that in your ratio at all. Then we have the judges talking about the same things in each judgment. So what you do is you go down here and you say to yourself, there were a number of different things that formed part of the ratio of this case. One of them was whether it was intended to be a binding promise, a legally binding offer. Okay, so was it intention to be create legal relations? And then you put down what each judge thought if they all thought the same thing, came to the same decision, which they did, then you just say, yes, it was intended to create legal relations. Now, in this case, you had at least 2 of the 3. I can't remember what Smith said. But what was the evidence that there was intent to create legal relations? It was the deposit. Okay? It showed their sincerity. Okay. Then you go back and you go through each of the... Okay, so there we have here. Was it made with all the world? Was there a notification of acceptance? Did there have to be notification of acceptance? Was there consideration? Did there have to be consideration? Okay, so you go down and then you work out where the consensus was. Importantly, as I said before, you're looking for not just the actual conclusion, but the reasoning used to get to the conclusion. If you have 2 out of the 3 judges that use the same reasoning to get to that conclusion, then you're away. You've got a ratio there, okay? And then you might have a few different points there for your ratio, and that will be your case note for Carlyle. If you wish, and you are very diligent or have nothing better to do, you may go through and you can look at the other offhanded comments that the judges made, and that will form your obiter. So I hope that this assisted. If you have any queries, let me know. Otherwise, I look forward to discussing your case notes with you. Hopefully, this will provide you with a good grounding to go on with some more confidence to look at the homogenous case, which we'll be looking at for week 2 and doing a case note for week 2, intention to create legal relations. That's a much longer case. Conveniently, though, you have most of the judges except for Kirby. Bless, Kirby loves a dissenter. Loves a dissent. So you have 2 main judgments for homogenous to look at. And so because you have most of the judges forming that majority judgment, you know that whatever is in that majority judgment, the reasoning that they use to get to a conclusion will be the ratio for that case. Okay? Like I said, any queries, give me a yell, post up on Facebook, or put something on Moodle, or send me an email, or give me a call. Anyway, thanks guys.